The Agenda with Steve Paikin is made possible through generous philanthropic contributions from viewers like you. Thank you for supporting TVO's journalism.
Tonight, is the federal government relying too heavily on binding arbitration to resolve labor disputes? Then, Steve Paikin speaks with two experts on the progress being made in the lifting of long-term water advisories in First Nation communities. That's all ahead on The Agenda. Port workers in British Columbia and Quebec, railway workers across Canada, WestJet mechanics in Alberta. In all of these recent labor disputes, the federal government sent workers and employers to binding arbitration. Does the use of this section of the Canada Labor Code remove the rights of workers? And if it does, what does that mean for labor peace across the country? For more, we're joined by Ian Lee, Associate Professor at the Sprott School of Business at Carleton University. He joins us from the nation's capital. And here in studio, Rafael Gomez, Professor and Director of the Center for Industrial Relations and Human Resources at the University of Toronto. Stephen Barrett, partner specializing in labor law at Goldblatt Partners LLP. And Laura Walton, President of the Ontario Federation of Labor. Thank you, everyone, for joining us in studio. Really appreciate it. Ian, for joining us virtually as well. Stephen, I'm going to start with you. What is binding arbitration, and when is it typically introduced in a labor dispute?
So when you're in collective bargaining, there's generally two ways to resolve the dispute. One is through strikes or lockouts, and the other is through binding arbitration. In Ontario, binding arbitration applies automatically in certain sectors where the workers are deemed essential, so hospital, firefighting, and police. Unions and employers can voluntarily agree to binding arbitration. That happens infrequently. Or where there's a strike that from the government's perspective has gone on, or a lockout too long and is causing serious damage, governments will sometimes impose back to work legislation, and that is almost invariably accompanied by binding arbitration. And what that means is that instead of the parties having to negotiate their collective agreement, it gets imposed by a third-party arbitrator.
All right, Rafael, how long does an agreement determined by binding arbitration actually last?
Well, that can depend, but can I correct something that Stephen just said?
Already.
He said there's only two ways that you can, find an agreement, through a strike or through binding arbitration. There's a third way, at the table. 98.6% of collective agreements. Remember that. 98. It differs by province, but you're looking in the upper 90s. So most of the time, the deals are struck at the bargaining table, close to the line, but before a strike or a lockout happens, just to put that out.
Can I just say in response to that, though, you're absolutely right, but the parties usually know the rules under which they're bargaining. So if you know that strike lockout is the outcome, then you bargain knowing that that's the leverage you have. If you know that binding arbitration is going to be imposed, you bargain that way. What's going on here that I'm sure we'll talk about is something quite different with Section 107.
It's the messiness of the federal jurisdiction in intervening sometimes and not intervening other times, creates chaos. And this average, you'd think, okay, 98, 99%, but in the federal jurisdiction, there's only so many employers, and yet all of them have seemed to have gone on some form of
Well, we will talk about that.
All right. But your question.
Yes. So how long does an agreement determined by binding arbitration actually last?
Well, the average length of any collective agreement in Canada varies, but 2, 3, 4, 5 years is not uncommon. Binding arbitration can do the same. Like you have an agreement that has a certain life. You kind of get a good arbitrator reads the room, understands what both parties need. But to your question, it was nicely phrased at the end. Is this leading to more disruption down the road? It can. Right, if you put a bottleneck on what parties could have achieved through bargaining, you're just setting yourself up for a worse outcome later. However, having said that, an arbitrator has to impose a deal and put themselves in the frame of mind of what would have been negotiated. So a good arbitrator plays out a scenario. What would happen if this had been a lockout or a strike? What would have been the terms and conditions that could have been negotiated? So good arbitrators do try to follow through in this what-if scenario, this sort of future world that would have happened but didn't.
Okay. Ian, I'm going to bring you in here. If you help explain sort of the process of binding arbitration sort of in practice for both workers and employers.
I'm going to defer to the labor scholars around the table, but while I've got my opportunity to speak, I just want to put on the table some empirical data. I published an article called Striking Out in 2012. And I went to, because there was a discussion at the time, Harper was legislating the postal workers back to work, and there were some pundits saying this is unprecedented, never happened before. And anyone who's old enough to remember the postal strikes of the 60s, 70s, and 80s and 90s knew that that's simply not correct. So it was a lot of work. So I went to the Library of Parliament Research Branch. They're very, very helpful. I said, look, can you give me the list of every bill tabled in Parliament, 50 to 2012, that legislated workers back to work? And they were phenomenal. They were very helpful, and they gave me that list, first reading, second reading, third reading, House and Senate and Royal Assent. It was remarkable. 34 times Parliament, successive parliaments, Liberal governments and Conservative governments, legislated striking workers back to work. 32 of the 34 were in the transportation and communications sector. Not one bill was ever defeated in Parliament. I updated that this year to 2024, and the current stats right up to the present, 37 times from 1950 to 2024 legislated back to work, have been legislated back to work, and 7 in addition to the 37, 7 ministerial orders imposing binding arbitration under Section 107. So that's a total of 44 times. So it's there. Shall we say there's a precedent there? There's a practice there. You could even say 44 times is a lot, but it's always been transportation. Yes, the post office. If you remove the post office, it's been exclusively in the transportation sector. And so I argued that even though they have the right to strike, successive parliaments have said you may have the de jure right to strike, but de facto, we're not going to allow you to strike.
Before we get into the politics and the industry themselves, Laura, I want to ask, what issues are usually settled through binding arbitration? Is this monetary? Is this non-monetary?
Monetary. I mean, and I think that's the important piece that we need to remember is, typically in binding arbitration, you're able to settle the wages issue, maybe some sick leave if you're lucky, doubtful, but it's typically compensation matters. The real problem is that that's not just what you go to the table to do.
Right.
When you are going to the table to negotiate with the employer, you're looking at working conditions, you're looking at health and safety, you're looking at those pieces as well. And those are the things that typically do not get addressed in binding arbitration. To your point, the ability of the arbitrator to project what may have possibly happened had we had the opportunity to properly negotiate gets very muddied when you start talking about the health and safety, when you get talking about the ratio of a worker to a client or a student or a resident. Those things don't tend to be dealt with in binding arbitration. So what in fact happens is that real big pressing issues, right? Because those are pressing issues. That's why folks have brought them to the table. They just get pushed off down the road to the next time that you get to bargaining, and the next time and the next time. And so what you're doing is you're actually creating a pressure cooker where workers' demands need to be met. And if not met through, the legal avenues that they have, then when do they get met? And I think that's why, you are setting yourself up for more disruption by not allowing the process to actually play out in the way that it has been intended.
Very good. All right, we are going to show a clip here. This is a clip of Liberal Labour Minister Stephen McKinnon speaking in Ottawa on November 12th. This was at a press conference he held after invoking binding arbitration on port workers in British Columbia and Quebec, including removing their right to strike.
There are a lot of working Canadians whose jobs depend on our supply chains functioning. I mentioned some of them in my statement: auto workers, potash workers, farmers, small business people who need merchandise for their shelves to sell at Christmas. So I view actions to restore order, reasonable actions to restore order in our supply chains as being pro-worker.
Ian, I'm coming to you. That last word there, pro-worker. Do you agree that this call for binding arbitration is, as McKinnon says, pro-worker?
Well, first I will disclose I just finished publishing a paper on this, and I certainly don't deny, and there are some very distinguished people around the table who know far more deeply the Supreme Court decision of 2015 that said workers have the right to strike. But that decision, and I have read it, never said that every last living, breathing Canadian has the right to strike. Of course RCMP doesn't have the right to strike. Of course the armed forces don't have. Of course ambulance workers and OPP, and it goes on and on. Treasury Board of Canada, the employer of the Federal Public Service, has designated 46,000 people out of 120,000 in PSAC as essential services. So my point is, it's not that abnormal. There is a provision for essential services. But to your point, and I will put on the table and acknowledge, the ports and the railroads are not in the federal public service. They're not employees of the government. They are the private sector. But what the minister is arguing, and I have to agree with him, is that I don't think that the Constitution is an economic suicide pact whereby we're going to bring down the economy. And let me just unpack that before I hand it back. The supply chain in Canada, the railroads and the ports and the trucking industry are not a tiny little bit or piece of the supply chain. They are the totality of the supply chain. They are the backbone of the economy of Canada. 40 million people, $2.5 trillion. And so people across the country are completely dependent on those supply chains from operating, whether it's retail, Canadian Tire, Home Depot, whether it's restaurants, it's automobiles, it's wheat. The totality of the country is dependent. And so I am not arguing that they should have the right to strike removed. In my paper, I used the American model, which was tabled in 1926, passed into law in 26, and augmented by President Roosevelt to restrict the right to strike by putting roadblocks, lots of roadblocks, so that you had all these cooling off periods. The moment negotiations broke down, you had to wait for 90 days. Mediator reports, got to wait for 90 days. So they put lots and lots of these roadblocks. They never removed the right to strike. But what they did was they introduced these cooling off periods throughout the process. And the end result was that they have far, far fewer strikes in this critical sector called transportation, because their economy is as dependent on transportation infrastructure and the supply chain as is Canada. So I'm probably going to be the skunk of the garden party, but I do agree that we cannot have serial strikes, as we've seen in the last 2-3 years, that are going to literally shut down the economy of Canada.
All right, let's get this table's reaction on there. Stephen, I'll start with you. Pick up on that, but does binding arbitration undermine workers' rights?
Of course it does. What the Supreme Court of Canada actually said in the Saskatchewan Federation of Labour case is that workers do have the right to strike, that it can be restricted, but only in limited circumstances, not preemptively, as is going on here, not if, and the Supreme Court of Canada also said, of course there's going to be an economic impact of a strike. That's what strikes are about. So, and as to Ian's comparison with the United States, cooling off, which is actually built into our labor relations system, is very different than completely eviscerating the right to strike, which is what the Minister of Labour has been doing with the Section 107 orders. And just on that front, back to work legislation, I agree with Ian, has a long history in Canada. Rightly or wrongly, it's been struck down, including in the post office context, as violating constitutional rights and not being justified. What's unprecedented here is the minister using this power in the Canada Labour Code as if he can completely undermine all the rights in the, not only in the Canada Labour Code, but also in the Charter of Rights and Freedoms. That is what's unprecedented, and doing it preemptively. And all you have to do if you're an employer in the sectors that Ian's concerned about is lock your employees out, and the minister is going to end the ability of workers to strike in response and impose binding arbitration. And as Laura pointed out, although arbitrators can deal with some of those issues, health and safety, technological change, hours of work, the very issues in the Port Authority case, in the Canada Post case, in the case of the railway workers, those are all important issues workers have raised. Arbitrators are inherently conservative. They are afraid to intervene in the workplace because they don't understand how it works, quite rightly. And you know who knows how the workplace works? The parties, the employer and the union, and they should be permitted to try to work those things out, as Professor Gomez said.
I'll get Gomez in right there.
I think Laura wanted to pipe in.
Yeah,
I heard you over my shoulder. I'll let you
I
off for a point.
The sky is falling idea of all times that everybody goes to negotiations ends up in a strike is just completely false, and it's this urban legend that needs to stop, right? So there isn't serial striking, you know, and I respect what you're saying, but there is not serial striking. There are far more collective agreements that are reached through the natural progression of negotiations. But when we see somebody step in and interfere before we even get there, that's where we've got a problem. So I am very hesitant whenever I hear somebody say, well, we've got to put these things in place because there's this serial striking. No, there is not serial striking. And I think that, using that and trying to use that to whip up this like, oh, sure, let's do that is very problematic because you're stripping away the very right that workers have enshrined in the Charter to be able to do this. And on both sides. Employers also have the right, and it's not very often that I speak on behalf of the employer, I think everyone knows, but they also have the right to negotiate at that. And I think the point of locking out your workers so that you can get this order is very problematic, and it will be used. It will be used in that manner.
Before I come to Raphael, I know, Ian, I can see you want to jump in, so I'll get you in there.
I do. 2 points. I'm not advocating, and I don't think the minister is, that this is something that should be applied across the entire framework of collective bargaining. If he isn't, I am referring only to the transportation sector because it is so crucial. We're talking the Port of Vancouver, the largest port in Canada, the Port of Montreal. We're talking the railroads, which ship over $400 billion of stuff to all the stores and all the businesses and all the villages and across Canada. And secondly, not talking about removing the right to strike. In the American model, that model only applies to railroads and airlines. It did not, the Wagner Act applies to all the rest of collective bargaining. So this was a special carve out they did only for transportation because it's so essential. That's what I'm arguing. And secondly, it's not the abolition of the right to strike. It's just saying at every step of the way, when something happens in the collective bargaining, there's an automatic legislated 90-day cooling off period. Now, whether we go 90 days, 60 days, whatever, there are deliberate barriers put up so that there isn't a rush to strike or a rush to lockout that causes people to cool their jets. And this is only in transportation.
So maybe I can offer a little perspective. So when I said earlier most agreements are settled, just to qualify with Steve, what it's true is that since 2022, we've had a real uptick in strike activity, partly because of measures that were taken during the pandemic. We rolled over collective agreements that would have otherwise expired because these industries were deemed as essential. Things weren't dealt with. Right. So collective agreements weren't reopened when they should have. And also, striking didn't happen across the board. In provinces enacted emergency law. So there was all this pent-up negotiating that didn't happen, inflation that spiked. So collective agreements have emerged from that period as sort of bellwethers of, I think, a lot of the problematic steps that we're taking during the pandemic. But that's an issue. The second thing is there is a public interest, I think, in the federal jurisdiction. It's why we have 10% of our economy that's regulated at the labor side from the federal jurisdiction. Banks and so on are regulated, transportation. And there is a public interest argument. That is that strikes take on maybe not the level of an essential service in which life or death is at stake, but a public interest is. And that's why back to work legislation has historically been tabled. But now to square the circle, Stephen is correct. This government has weaseled out. It's used this Section 107 to confuse the parties, Ian. No one knows what the government's going to do. Are they going to intervene or not? That produces chaos, uncertainty. Parties don't like that. To your point, employers and unions suffer in this chaotic environment, all at the hands of our federal labor minister.
All right. I want to make sure we've got a lot of stuff I want to cover, so I want to make sure we get in there. But Raphael, I want to come back to you. Ian had made a point there. Employees in the private sector, should they be considered essential?
Some, potentially. The point is, even when you blank, the problem was that I defer to my legal friends, Stephen here, but the broad brush, that Saskatchewan case was actually really good. What the government tried to do there was bully tactic. The entire public service was deemed as, and that creates a counter reaction. So is there a case for a private sector employer that would be deemed essential? Possibly. We'd have to find out what those would be. But even in those cases, you do want to encourage parties to negotiate as far as they can with as much leeway as possible at the table. It's like complicated. There's so many issues that have to get worked out. Allowing parties to do it is usually the best way, and most of them do it. When there's certainty, here's the issue. The worst case scenario was the ports, because in the ports, they allowed a strike to happen and then invoked 107 anyway. So you have the costs of a strike with no benefits. Strikes that actually occur, yes, they have costs. But to have greater benefits if they're short because the parties realize what was at stake. What information were they withholding that they now have to reveal because of the cost of the strike? You basically had a costly strike with absolutely no benefit because you invoked 107. As bad as it is, if you're going to use 107, do it before the strike because the strike is pointless. It's actually worse. So we don't have either system right now. If they wanted to really be clear, they said, we deem these sectors so important, we're willing to fight another legal battle over this. They are not going to go on strike under our watch. We will impose back to work legislation and they'll have an arbitrator figure out the rules. This in between is bad for everyone.
Okay, we'll pick up on that. You mentioned Section 107 a number of times, and I want to make sure, let's take a closer look at Section 107 of the Canada Labour Code. It reads, the minister, where the minister deems it expedient, may do such things as to the minister seem likely to maintain or secure industrial peace and to promote conditions favorable to the settlement of industrial disputes or differences, and to those ends, the minister may refer any question to the board or direct the board to do such things as the minister deems necessary. All right, when we mention board, of course, we're talking about the Canadian Industrial Relations Board. I am curious, I actually want to talk about Canada Post. That's in the headlines right now. That is what a lot of people are looking at. But I'm curious about binding arbitration. Maybe something that would have happened in the past, but not in the case right now. We are kind of standing there. Should these workers be deemed essential? Why or why not?
Whether they're, it depends what you mean by deemed essential, but should these workers, the real question is, should these workers have the right to strike? And of course they should have the right to strike. And, it may well be that if a strike goes on for an incredibly long period of time and the government believes that there's serious damage being caused as a result, that the government might legislate them back to work, and the workers could challenge that, as has happened. But to effectively, this use of 107 is to preemptively completely override the constitutional right to strike, and of course that shouldn't be permitted. In fact, as Laura pointed out, we know that when that happens, the next round of bargaining is even more contentious, and you don't get at the real issues. So arbitration where workers are truly essential, public policy in Ontario, firefighters, hospital workers, police. But to resort to imposing arbitration outside of those circumstances automatically undermines collective bargaining, which is constitutionally protected, and there's really no justification for it.
All right, Laura, I'll bring you in there. Why does the government not implement back-to-work legislation for Canada Post workers?
Well, I think I'm not them, so I'm going to say that right now. I don't profess to be them, but I think the one thing I just kind of want to loop back to is we have to remember and center the workers in this entire thing. So to just deem somebody essential means that you do actually understand that the labor being provided by the workers is what's making the economy go round. Without workers, the economy doesn't exist. And I think that's the thing that I want folks to kind of put centered in here. We don't get further as an economy by racing to the bottom. And that's what you find typically will happen is, let's put more pressure onto the workers. The one question that I would be asking right now from the Canada Post perspective is, my understanding is that the employer is seeking concessions. If the work is so important, we all know that the labor being provided by these workers is fundamental to what makes us Canadian, right? They are tasked with delivering mail to the most remote parts of our country. That's pretty important. I think we all can agree there. Then why is the employer seeking concessions for the very workers that make that happen? And that's where I think we need to really start, let's center the workers. Without workers, you don't have an economy. That's what we need to remember. And when we start messing with that, you start actually just deflating that, and it actually deflates our economy. You actually end up with people in cost of living crisis. Why? Because they have not been able to negotiate what they need to in order to continue. That is super important. So I think from this perspective, I am not the government, nor do I ever really want to be said government. But I think, before we start looking at just what the workers' demands are, let's have a little bit of a gander at what the employer is asking for. And, this isn't just about a group of people standing on the street in the cold. I've been on strike. Nobody takes that decision lightly. That's a very difficult decision, to go out on strike, to put away any sort of wages that you're receiving, benefits, etc. But I also want to remind folks, If it were not for the CUPW workers that took a strike, we wouldn't have maternity leave the way that we have it now. And so there is huge benefit to our society by brave and bold workers making that very difficult decision and forcing the hand of the employer to do the right thing.
All right. I want to come back to the board and get a better understanding of what the actual role of the board is. Raphael, can you help us understand how much power do they have? Or maybe I'll put this to you.
We were having a conversation about this before we knew about this ever happening. Why is the board being sidelined? The Canadian Industrial Relations Board works, I think, both on its de jure power, what it says in statute, but also its normative, trust with the parties. It's really being sidelined here. So my understanding of Section 107, we can get into a debate, is that it should have been up to the board to push this back. If the minister can refer it to the board could really look at case-by-case basis and to maintain its independence say, no, I'm sorry, this does not qualify. There wasn't even a strike yet. There was a one-day lockout. They could say, no, let the parties take some time, and then we could use it. The fact that now the board is very scared to oppose the government's sort of message, it undermines the board's authority. So now we're getting into this, bad backsliding of institutions that have taken generations to build up, that are there to serve as neutral kind of third parties between employers and the unions. And that is being chipped away and eroded. My reading initially, I thought, and I remember doing an interview, I go, well, it's with the board. They could send this back. And, they were just very much, no, the minister has said it. We have no way of opposing this. And we're in this weird period, right? Where, as Professor Lee was mentioning, most of the time this has been brought forward to Parliament. Good or bad, at least it's aired there. And there's a government that's putting their legislative track record on the line during the next election. Again, this is a circumventing that.
Right.
And I think that's what's, chipped away at the neutrality of the board and its respect amongst the parties, and that's not a good thing.
All right, Ian, I'll get you in on that.
I want to follow up on that because this is a very important point. And forgive me for using the language of economics, but in my view, Section 107 is becoming a substitute for back-to-work legislation because this government and other governments know that it's very contentious. The NDP has, from its very foundational origins, has always opposed every back-to-work bill in Parliament because they're philosophically opposed. And of course, it gets a lot of debate and a lot of it's very contentious. And so in the last few years, some politicians, some ministers of labor found out there was this backdoor method of 107, and it's a substitute for going to Parliament, which is messy. You got to have them all there. You got to introduce bill first reading, second reading, third reading. Then it's got to go over to the Senate. Senate can kick it back. It's messy. It's inefficient. And I'm being a little bit facetious when I say that. And so what this suggests to me is that after the next election, because it's not going to happen in this lame duck Parliament, there should be major revisions to the Canada Labor Code, and including possibly removing transportation out of that and under its own regime of collective bargaining, and addressing the flaws in 107. But there's clearly flaws in the current model in Canada, or we wouldn't be having this conversation right now.
Fair enough. Stephen, I'll get your take on some of what's been saying.
Well, I mean, democracy is messy, for sure, but what's the alternative? The alternative shouldn't be government edict to end workers' fundamental rights. So, whether back-to-work legislation is or isn't appropriate, the courts have ruled that workers are entitled to strike for a period of time. It may be that the strike goes on for such a long period of time that there's serious damage to the economy, but not automatically, preemptively at the beginning. And, the example in that Ian speaks about in the United States of these cooling off periods, well, that's been part of the Canadian tradition forever. What has not been part of the Canadian tradition is simply imposing an end to the strike either before it begins or after it's been going on for a day or two. That actually is foreign, not just to the Charter of Rights, but to the Canadian tradition. So, and the cooling off in the United States still ultimately respects the right to strike. It may be that it delays it. So to that extent, I think probably Ian and I agree. Section 107, I think it's a unique provision in the federal jurisdiction. No other province has it. If you're going to take away workers' fundamental constitutional rights, you should at least have to legislate. And it might be messy, and it might be a minority government. It's challenging. But, you know, and I see Ian nodding. I think we agree on that. 107 is not the sort of device that should be used to undermine what the Supreme Court of Canada, and I think all four of us agree, is a fundamental right, which is the right to strike.
All right, Stephen, I actually want to stay with you. The unions representing railway and port workers say they will appeal binding arbitration, the orders that came. What will the union's arguments be in court?
Well, in court, there's actually many different proceedings that are going on now, but fundamentally, they'll be relying on the constitutional right to strike, and the fact that in order to override that strike, you have to have very powerful reasons and evidence that the strike is causing harm, serious public harm. But it's not just this issue is now also before the Canada Board, because in British Columbia, the board is now going to have to decide the issue that it's sort of avoided up to now, which is whether invoking Section 107 undermines the constitutional protection for the right to strike, the right to collectively bargain. And that's actually, I think, being heard December 9th and 10th initially by the Canada Board in BC.
What I hear is this sounds costly and takes quite a while.
Well, they were pretty quick to invoke 107 and get quick orders from the board, but for sure it's costly for unions to have to challenge and vindicate workers' constitutional rights. It takes time, but what alternative does one have in the face of a government resorting to a provision that I'm not sure was intended to be used in this way, and until now really hasn't been used in this way.
All right. Laura, I'm going to come to you. You mentioned a little bit about this, but in the last few minutes that we have, collective bargaining. Why is it the preferred or negotiating preferable to a binding arbitration order?
Well, I think when you think about it, it's when you're doing collective bargaining, your collective bargaining process is the worker's voice at the same level as the employer's voice. When you go in there, you're equals, and you're presenting your proposals, you're trying to find where there is a happy medium. And because we know so many actually are solved before we ever have any sort of labor disruption, we know that it happens. We know that when the work is done, that it is happening. And so that allows for that to happen. When you head into binding arbitration, I also wanted to say that binding arbitration can take a long time. It isn't always as quick as one would like. It's not unusual for there to be months of waiting before these things are solved, which also just adds that little bit of pressure onto that pressure cooker as well, right? We're putting it off. So, wherever we possibly can, free negotiated collective agreements with the parties there. They may need a mediator. They may need to, bring in somebody. That's fine. But removing that completely away and just relying on some arguments being heard and hopefully the arbitrator being able to insert themselves into what they believe the workplace needs is never going to come out with the same sort of thing that would happen when you have a group of people who is performing the work, a group of people who is overseeing the work, and they're, putting together what that collective agreement should look like.
All right, Raphael, you get the last word here.
Oh, wow.
Less than a minute here.
Boy.
So.
Well, I can do two things. One, the economic analogy. When we have interventions that are a bit sporadic and not consistent, it creates uncertainty in the parties and leads to disputes that would otherwise have been negotiated actually spilling over into a strike. That's the irony.
Right.
Of not having clarity, we now have a 2-week postal strike that might not have lasted as long. Secondly, the other flip side of it is that arbitration is a very well-developed and deeply ingrained institution in Canada. We have some of the best arbitrators in the world. So we're not denigrating arbitrators when we say we don't think binding arbitration necessarily is the go-to option, always. Negotiated settlements are. Having said that, conditional on that, our arbitration system is probably one of the most valued and respected in the world. We train arbitrators around the world. So we're not going to get the best, perhaps, resolution from this, but we will have arbitration that is at least procedurally just and as fair as it can be.
All right. We are going to have to leave it there. Ian, Laura, Raphael, Stephen, thank you so much. Really appreciate it.
Thank you.
Thank you.
Canada and First Nations communities have made progress in rescinding long-term drinking water advisories since 2015. But Ontario has more such advisories remaining than any other province, and some of them have lasted for years. Why have some communities struggled to get these advisories rescinded? And what does success look like? Let's find out. We're going to ask in Thunder Bay, Ontario, Glenn Goodman. He's Director of Operations for the Ontario First Nations Technical Services Corporation. And in the nation's capital, Irving LeBlanc, former Director of Infrastructure and Safe Drinking Water and Sanitation with the Assembly of First Nations. And we're delighted to have both of you gentlemen on our program tonight. I just want to start by having our director, if you would, Sheldon Osmond, put up a map of where things are at in the province of Ontario. And for those who are listening on podcast, this is a map of the province where the water advisories, I guess there are red dots where we have problems. There are green dots where we've made some progress. And I guess I want to find out from you, Irving, we'll start with you. How does that map look to you in terms of where you think we ought to be today?
Well, I think it's very indicative of the current situation that there are more red dots in northwestern Ontario, and that's supported by the Chiefs of Ontario, who monitors that very closely. But also you'll see some dots below further down south. So it's not limited to Northern Ontario, but obviously that is the majority of the long-term drinking water advisory still there.
It is interesting, Irving. We did see on that map there are a couple of red dots, 3 red dots actually within a short drive of Toronto, actually, an hour or two, maybe 2.5. Yeah, there we go. Thanks, Sheldon. Why would we be having water advisory problems? Maybe, Glenn, I'll go to you on that one. Why would there be water advisory issues so close to the capital city of the province?
Well, it's all related to infrastructure and the investments that are being made by the government of Canada to assist First Nation communities, specifically those 3 down in the Southern Ontario region. And I should add is that there are infrastructure development projects underway with building brand new water treatment plants in almost all of the instances that you're seeing with red dots on that map. So, as time is of the essence, which is an understanding and a critical point. But at the end of the day, with the amount of investment being made, and that's been approximately $2 billion over the last 4 years when it was initially announced by the current federal government, is that it's taken some time in regards to making traction into the communities, getting them to understand exactly where those investments are best utilized to address those circumstances and get them off the long-term drinking water advisories. And it's a major piece is because not only are you looking into investments as far as building new equipment, new water treatment plants, new distribution systems, but training is also a critical piece as well for the operators that are responsible for those pieces.
Yeah, we're going to get to that training piece in a second, but I do want to, we should look at this, compare and contrast decade by decade by decade. And Irving, as you look at the record of the Liberal government federally over the last decade, how does that compare to previous governments?
Well, this is where I'll be careful not to get into previous regime and the current regime, but the current regime definitely talks about how many long-term drinking water advisories they have lifted, and I think that's part of their website. But they have made commitments over the years. But the problem is that the long-term drinking water advisories, as you see there today, when a community has been on a drinking water advisory for more than a year, it slips into a long-term drinking water advisory. So it only takes a year for that record to be established. So it's kind of as I've been looking at some of these monthly water tracks reports, it's kind of 2 steps backwards, 1 step forward. So as some of these probably not a good word, mature into 1 year, they go on to the long-term drinking water advisory, and they can stay there long if they're not being addressed.
Maybe I can get Glenn on that as well. How does this current Justin Trudeau government compare to previous governments in terms of progress on this issue?
Well, Steve, I'd like to point out much credit to my colleague here. And we're not, OFNTSC doesn't align itself with political oversight. We're a technical service provider to provide services to First Nations throughout Ontario. But comparatively, if you talk over the last decade, the investment being made by the federal government currently in power has never been seen before. It's unheard of. And hence, that type of investment is really attributing to ending long-term drinking water advisories in the majority of the communities when we speak to the province of Ontario.
Okay, I think that's worth putting on the record because I don't know if either of you have checked the polls lately, and this is not a partisan comment, but the current federal government is in some trouble and never really gets any credit for anything these days. But Glenn, if I hear you right, you're saying that they've made unprecedented steps forward compared to their predecessors. Is that true?
I agree with that statement, Steve. Like I say, there's been some significant gains made at a First Nation level in regards to water industry-related issues, especially with the investment towards infrastructure and the investments that are being made towards training. So hats off to the persons in particular that make those types of decisions at a senior level in the ministry offices.
Okay, Irving, follow up on that if you would by telling us what, in your view, are the biggest obstacles still being faced by the communities where the long-term boil water advisories are still in place?
Okay, I'm going to date myself here, Steve. I've been working on this for quite a while. Ever since Walkerton happened, I worked with the Chiefs of Ontario on that. And my time at the Assembly, we met with the former Minister of Indian Affairs, for the late Prentice, and we asked him what's going to take to clear these long-term drinking water advisories, and he said it's just a matter of money.
This is Jim Prentice, the former Conservative Minister of Indigenous Affairs?
Right.
Yeah.
That's right. And that's still the situation today. If there was enough money put towards it that's required, probably identified in the closing the infrastructure gap, these would be addressed. And you're never going to get away from drinking water advisories. Some of them are transient. You have a burst pipe, you have to put a drinking water advisory on. But these long-term ones are the ones that need to be addressed. These are the ones where people, elders, young people, others have suffered, as you mentioned, one over 20, 25 years without safe drinking water, without being able to open the tap, even though they might have a system there, but the water is affected that you cannot use. So I think the plan, the hope is that those long-term drinking water advisories should be eliminated, as promised by Prime Minister Trudeau back in 2015.
Glenn, can you just give our viewers who do not live on reserves, and I'm going to assume that that is the vast, vast majority of our viewership and listenership, can you tell them what it does to a community when you know you can't turn on the tap and drink what comes out of it?
It's a matter of trust, Steve. If you can imagine, we have many communities across Canada, First Nations, that are suffering long-term drinking water advisories and effects of for decades, applicably generations. So when you speak to that trust factor is even what we deal with internally with the OFNTSC in the development of projects and proposals that are submitted to the federal government and receive approval. And we build brand new water treatment plants in First Nation communities. You can imagine when you're talking 2 to 3 generations that have been on long-term drinking water advisories, to get them to appreciate and understand that water that is now coming out of their tap is safe to drink. You got to take into consideration First Nations have been under oppression, under a colonial regime for 250 years. These changes that we're speaking to that are going to move our communities positively forward, they're not going to happen overnight. It's going to take decades to make those changes, and a good place to start is ending these long-term drinking water advisories.
How, Irving, has climate change made it more difficult to make progress on these issues?
Well, definitely, it's First Nations are being more severely impacted by floods, fires, and severe windstorms that really impact the quality of water. And many of these drinking water advisories are shown to be type 1, serious deterioration in water quality. So it's a never-ending work to monitor the quality of your water coming in, especially with the north. And we see now that Attawapiskat First Nation is now has a litigation on their long-term drinking water advisory. They do have water, a new plant that was built somewhat recently, but the quality of the water, which is full of organics, continues to have disinfected byproducts, which result in carcinogenic trihalomethanes. And the nation, people know there is something in their water, even though Health Canada will tell them, you probably have to drink 10,000 gallons a year for the next 20 years for it to affect you. They know there is something in their water, and that's why they don't drink it. And that's why there was a reverse osmosis plant put behind the treated water, so they are now treating the treated water so that First Nations can get relatively safe water. So that's part of that whole process of severely deteriorated source water, and that's another thing that needs to be looked at. First Nations need to take control of their source water, not just within their lands, as the Safe Drinking Water Draft Act says, in, under, and on First Nations land. It has to go beyond that.
Well,
so
that's a good.
Why these,
yeah, let me just jump in there and say that's a good segue, actually, to take me to Glenn and to circle back to something we talked about a few minutes ago, which is how much of a problem has it been, Glenn, to make progress on these issues in terms of a lack of expertise on reserves, in terms of a lack of training for people to actually operate and maintain the water treatment facilities they have on reserves? Talk to us about what part of the puzzle that is.
Well, the difficulties that I'm experienced with in regards to facilitating support services to the First Nations, and if we could revisit your map, Steve, is if you look predominantly, most of the drinking water advisories are in the far north or remote communities. And that in itself, when you make considerations of the distances, right? So to get that infrastructure in there, even if you have a catastrophic or a major component fail in those communities, you're speaking a long distance and you're speaking to a considerable amount of time. Because the O&M investment hasn't been made for a lot of years through the federal government's support, is that we're finding that these major components that are subject to failure don't even have replacements available off the shelf in major centers or municipalities, right? So that's a key point to consider when you're working with First Nations and the training piece. We pride ourselves in what we've done, and we currently manage a program supported by Indigenous Services Canada called the Circuit Rider Training Program, where we've lined ourselves up with provincial regulations, and we train operators in First Nations to become certified to provincial levels of certification for the plant that they operate in their community. But the difficulties are, again, when you speak to geographics, it's facilitating that training that they need directly in their community, which our Circuit Rider Training Program facilitates. But then again, when you're dealing with old or aged equipment, it comes into placement of, consideration for when that component is going to fail, which is highly likely, or a higher percentage now with the age of a lot of the plants in the First Nations.
But I presume, Irving, that the long-term solution to this problem is having enough people on site who have the talent and skill and training to maintain and repair these water treatment facilities when they become problematic. And to that end, I guess that means making sure that enough young people are interested in this as a potential career. How do you do that?
Good question. I'm glad you brought that up. One of my pet projects is to interest young Indigenous students, First Nation students, to become interested in water careers. And that was one of the things I worked with Queen's University, where they work with new students coming into the university, and they help them every which way, every way they can to help them, make them succeed. So part of that is doing that. But as also Glenn mentioned, when you get to the community level, working with the operators that are successful and showing the community and the young people that you can make a career out of this, and that it is something that really helps the community in terms of safety, providing the safety for the members. So it is a good career to get into, and something we hope to see more and more young students get into those careers.
Glenn, I wonder if, and again, we're going to harken back to that map. Sheldon, maybe you could put it up again. There are still too many red dots on that map. And I wonder if you can tell us, are there any First Nations on that map who are never going to have clean, safe, reliable water?
You know what? I'm confident that in a very short time, with the level of support services and the history and from a perspective of commitment, Bing and myself are relatively aged. It's going to be the youthful generation that is going to replace us, that are going to realize the successes that we're envisioning now and we're putting into place into those communities. Those communities that you see with the red and green dots, they will get off their boil water advisories. They will get off their long-term drinking water advisories, but it's got to be a wholesome approach with support of the federal and provincial governments, First Nations holding the accountability factor with their operators, and then individual organizations such as the OFNTSE being able to facilitate that educational component that is so critical, right? Is our leaders almost 30 years ago, Steve, had the vision at the time the Walkerton situation arose, and they seen that this could be a possible issue that would arise in a First Nation community, similar to what happened in Walkerton. So they, on their own decision, passed a resolution that aligned all the First Nations in Ontario with Ontario water regulations, which are some of the most stringent in the world. And so as we move forward, as we implement the application of the regulations and the training that is tied in with the provincial certification process, and get operators to the level of certification that is necessary to, and be confident and have the expertise and have the background in regards to operating these major pieces of infrastructure that are now costing anywhere from $30 to $40 million to build, right? I'm confident to say that we'll press forward and probably relinquish them all or rescind them all in the next 10 years.
We should just remind our younger viewers, there have been a number of references here to Walkerton. Walkerton was the water tragedy that took place in that part of sort of central Ontario. It's 25 years ago almost already, almost 25 years ago. A combination of bad policy, bad performance, bad everything that resulted in a lot of people drinking tainted water, 7 dead, thousands sickened by what happened there, and obviously a commitment by many levels of government not to have that happen again. Let's do a clip here. Minister of Indigenous Services Patty Hajdu speaking about Bill 61, the First Nations Clean Water Act. Sheldon, roll it if you would.
Can you imagine that communities, and I'm sure many Canadians don't realize this, communities are at the mercy right now of the federal government in terms of the quantum of money that is spent on sufficiency of funding for water systems. That means that, for example, the amount for salaries for water operators could get arbitrarily cut by Canada. The amount for infrastructure replacement or for repairs or for training is at the discretion of Canada. And this bill changes that reality for First Nations.
Irving, in your view, is this bill going to make a difference?
I was hopeful at the start. I was part of the team that worked with the Indigenous Services Minister Hajdu's officials in developing. I'm going to say develop because it was not co-development as it turned out. But I was hopeful that would be that way. But as we get further into it, with all of the I don't know what the wording that goes into some of the causes, that does not provide commitment for funding. It just says we will work we will do our best efforts to meet those requirements.
And that's not going to cut it, I guess?
That's not sitting well with First Nations because they've seen the government say, we'll do our best efforts for too many times. They would rather see we shall, we must.
Glenn, how would you improve the bill?
Well, I'm disappointed by the level of political posturing that's currently taking place in moving this legislation forward in the House.
By whom?
But sorry, Steve?
Political posturing by whom?
Well, there's representatives of various political entities that are sitting and reviewing the legislation and are making decisions that are, from my perspective, delaying what is one of the most critically important pieces of the legislation as it relates to First Nations across Canada. So I'm of the opinion is that the faster we get this legislation passed is the better it's going to be supportive of First Nations and their water, drinking, or wastewater systems operations wholeheartedly in regards to developing new infrastructures, getting operators' salaries where they need to be, making consideration for the source water piece that brought into our conversation. Those are all critical pieces. But again, there's that unknowing, and I agree with Bing, is that there isn't a financial commitment.
And you'd like to see that?
I'd like to see that is because that's one of the biggest things that we struggle with in regards to the infrastructure and training support that we facilitate with Indigenous Services Canada to First Nations in Ontario.
Gotcha. Gentlemen, I want to thank both of you for coming on to TVO tonight. I think we know a lot more about this issue now than we did 22 minutes ago. So I'll thank Irving LeBlanc, the former Director of Infrastructure for the Assembly of First Nations, who's joined us from the nation's capital, and Glenn Goodman from the Ontario First Nations Technical Services Corporation, who's joined us from Thunder Bay, Ontario. Good of you to join us, gents. Until next time.
Thank you very much. Thank you for asking me.
Appreciate the opportunity. Take care.
And that is the agenda for Monday, December 2nd, 2024. Before signing off, we want to note that tomorrow is Giving Tuesday, and we want to share why your support for TVO matters. We think education and independent journalism are critical to shaping a stronger tomorrow. TVO provides programs that empower Ontarians of all ages to learn, grow, and stay informed. So, if you are inclined, please visit tvo.org/GivingTuesday. And we thank you for considering TVO among the many worthy causes you may be considering tomorrow. Speaking of tomorrow, we'll look at whether Donald Trump's tariff threat is all bark and no bite. Hope you'll join us for that. I'm Steve Paikin. Thanks for watching TVO, for joining us online at tvo.org, and we'll see you again tomorrow.